Yeah.
Let's see. Mr. Ceballos, you are the spokesperson for the claimants today?
Yes, I am, Mr. President.
All right. Is everybody accounted for on your side?
Yes, Mr. President.
Mr. Granet for the respondent, or Ms. Endicott, who is be the spokesperson for you, for your side?
Ms. Endicott will be the spokesperson as to the damages portion. But we are ready to go and also look forward to the U.S. intervention later today.
Okay, good. Everybody's on your side accounted for, Mr. Granet?
Yes, sir, we are all here. Thank you.
Okay, thank you. Any procedural point, admin point, householding? Mr. Ceballos?
No, Mr. President.
Mr. Granet?
Nothing from our side. Thank you.
And we can move to the experts for respondent. Ms. Endicott, you introduce them.
Thank you, Mr. President, and hello to the tribunal. We have with us today Matthew Schopp and Kiran Sikera from Versant Partners, who are available to present and to answer questions.
Thank you, Ms. Endicott. May I first ask who, Mr. Schopp and Mr. Sikera, who is the lead person?
I will be the lead person today.
Mr. Schopp, okay, you're the lead person. All right, let's start with you. Mr. Schopp, can you please state your full name for the record?
My name is Matthew David Schopp.
Mr. Schopp, you appear as an expert witness for the respondent.
I do.
Any questions unclear to you, please seek clarification. If you don't do so, the tribunal will assume you've understood the question and that you answer response to the question.
Yes.
Now, Mr. Schopp, you appreciate that appearing before a court or an arbitral tribunal and testifying there is a very serious matter. In that connection, the tribunal expects you to give the statement, the text of which will now be on the screen.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Then I move to Mr. Sikera. Mr. Sikera, could you please state your full name for the record?
Yes, it's Kiran Peter Sequeira.
Mr. Sikera, you also appear as an expert witness for the respondent. If any questions are clear to you, please seek a clarification, because if you don't do so, the tribunal will assume that you've understood the question and you answer a response to the question.
Yes, of course. Thank you, Mr. President.
And Mr. Sikera, you will also appreciate that appearing before a court or arbitral tribunal and testifying there is a very serious matter. In that connection, the tribunal expects you to give the statement, the text of which is in front of you.
Yes, of course. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Then, Mr. Schopp and Mr. Sikera, could you please confirm that you're together alone in a room, or you're in separate rooms? Because I see two different paintings behind you.
We are in separate but adjacent rooms, and I am alone, and Mr. Sequeira, I assume, can confirm the same.
Yes, I am alone as well in my office, which is adjacent to Mr. Schopp's office.
If anyone enters in your room, please alert the tribunal of this fact and refrain from testifying until the person has left the room.
Yes, of course.
Okay, thank you. Then, Mr. Schopp, can you invite you first to scan the room where you are?
Yes.
Okay, Mr. Sikera, may I invite you to do the same?
Yes.
Thank you. For the record, Mr. Schopp, can you confirm the location from which you are testifying?
Washington, D.C.
Mr. Sikera?
Washington, D.C. as well.
Gentlemen, before you start with your presentation, I have to draw your attention to a provision in procedural order number 6 about the manner of testifying. So this is paragraph 23, and I read it to you. Experts who have presented joint reports will be examined simultaneously. That means then your names appear, Mr. Schop and Mr. Siqueira. For the cross-examination of these experts, the questions will be directed to the lead expert in the group designated by the claimant's respondent, the previously selected lead expert. And the lead expert, that is you, Mr. Schop.
Correct.
The experts will be responsible for determining which expert among the two should respond to the questions. Only one expert can respond to each question. Each testifying expert should log on into a virtual platform separately and refrain from interacting with the other testifying experts during the examination, unless invited to do so by the questioning counsel of the tribunal member.
Yes.
Yeah. So, gentlemen, the last question I have for you is, could you please shut down your iPhones or other mobile devices?
Mine are shut down.
Mine is shut down and in a drawer.
All right. Then may I invite you direct examination. Ms. Endicott, you would like to invite?
I would like to invite Mr. Schop and Mr. Siqueira to please proceed with their presentation that they've prepared for you today. Thank you.
45 minutes you have, gentlemen.
And I will be doing a share screen if that is okay. Well, thank you, Mr. President, members of the Tribunal, for allowing us the chance to present to you today. My colleague, Mr. Siqueira, and I will be going over some of the key issues and damages in this arbitration. So, starting first with briefly a comparison of the experts' results. As you can see on slide 4, is a summary of the experts' respective damages conclusions. BRG concludes total damages of $47.6 million US with pre-award interest updated through the 1st of March 2022. This is comprised, as you'll see in the sort of orange and reddish row, a $31.8 million for the fair market value of claimants' investments as of 14 March 2017, $2.4 million in damages for what has been called the additional costs and expenses, along with $13.4 million of pre-award interest through the 1st of March 2022. Our damages conclusion is significantly lower. We reached total damages in the range of $10.9 to $11.4 million under the fair market value standard, and that includes $7.5 million US, for the value of claimants' investments as of March 2017. We used the same $2.4 million in additional costs and expenses, and we calculate lower pre-award interest of roughly $1 million or so US dollars through March 2022. So how are our results so different? Well, it's not due to our valuation approach. Both experts agree that damages for an expropriation or a full deprivation should be based on the fair market value or FMV standard. We also both agree on the use of a discounted cash flow or DCF valuation method supported by third-party offers to determine the fair market value. And we similarly agree that the claimant's sunk costs do not represent fair market value. However, despite this common approach, again, we reach significantly different conclusions. BRG calculates the fair market value of claimants' investments as of March 2017 of $31.8 million, whereas we calculate the same at $7.5 million. BRG's valuation, as we've explained in our reports, is 3 to 4 times higher than the third-party offers for claimants' investments, which range from $7 to $9 million. And BRG's conclusions are based on highly flawed DCF inputs that are irreconcilable, we would say, with basic financial principles. Our valuation, on the other hand, is consistent with these third-party offers and is based on a DCF which uses inputs that align with basic financial principles. And as to pre-award interest, again, a big difference in our results. That is because BRG relies upon high risk, economically irrational interest rates that are tied to claimants' cost of capital, whereas we use economically rational pre-award interest rates, including respondents' cost of borrowing, the yield on investment grade bonds, and the US dollar risk-free rate. So turning first to an issue that's been discussed at some length in our reports and yesterday, what is the fair market value of claimants' investments implied by third-party offers made for either some or all of their stake in CHM? Well, in this case, we're fortunate to have 5 third-party offers that each provide evidence of the fair market value of claimants' investments. And all 5 of these offers, which are listed in the table at the bottom of the slide, imply a fair market value of between $7 and $9 million for claimants' investments. And all 5 offers are representative of the value in the but-for scenario. In other words, they are unaffected by the breaches. So turning first to the February 2017 Interjects offer. This is one that was first discussed by BRG in its initial report, and then it's been continued to be discussed since then. Just to recap, what was this offer? Well, it called for Interjects to invest $17.8 million of cash into CHM over time to earn a 70% stake in the company. Interjects also would pay a $1.5 million development fee to Latam Hydro. And importantly, this offer was a subscription for new shares in CHM. It was a capital raise to be completed via direct funding of up to $17.8 million in the project's construction costs. BRG incorrectly interprets the Interjects offer. According to BRG, the Interjects offer implies a value of $27 million, which they calculate as saying Interjects would invest $17.8 million for a 70% stake, and they would pay $1.5 million to claimants. But that math is incorrectly assuming that Interjects was purchasing existing shares from claimants rather than subscribing to new shares in the company. So what's the correct interpretation of the Interjects offer? Well, it's that CHM would only be worth approximately $28 million. Our math is a little bit different, but would only be worth around $28 million after and only after Interjects injected this $17.8 million worth of cash into the company. The value of CHM before Interjects put in or would have put in the $17.8 million was $8.8 million. And in fact, claimants' investments could only ever be worth $8.8 million, regardless of whether they owned 100% of CHM before Interjects invested, in other words, 100% of 8.8, or if they owned 30% of CHM after Interjects invested, in other words, 30% of roughly $28 million. So we're going to go a bit more into the details here because this has been such an issue of contention between the experts. And we'll take it back to basics and talk about pre-money and post-money value and what those mean and when those terms apply. Pre-money value is simply the value of a company before funds are received from a new share subscription. Post-money value, on the other hand, is referring to the value of a company after funds are received from a new share subscription. And when does this matter, this pre-money and post-money distinction? We heard yesterday that it's only for venture stage or early stage companies where it's 2 people in a garage. That is simply false. Pre-money and post-money is relevant any time there is a new share subscription that raises funds for the company. It does not matter if the company is early stage, 2 guys in a garage, or a pre-revenue Series A, or if it's mature, if it's a bank that is getting recapitalized via a new equity investment, a bank that's worth billions of dollars and has been around for hundreds of years. Pre-money and post-money matters anytime there's a new share subscription. And what then is the relationship between pre-money and post-money value? Well, post-money value is simply the value on a pre-money basis plus the value of the new investment. So if you know what it was worth beforehand, you add the new investment and you can come up with the post-money value. And conversely, pre-money value, if you know what it's worth after the post-money value, you can simply subtract out the amount of the new investment to calculate pre-money value. And why is post-money value higher? Why are these two amounts different? Well, that's because new investment, a new addition of capital into the company, increases the value of the company itself on a one-for-one, a dollar-for-dollar basis. Most share transactions, if I log on to Fidelity or my brokerage account and buy a share from another individual, we exchange money for a share. The company isn't involved at all. It doesn't get anything out of that transaction. That sale doesn't affect its value. But in these share subscriptions, it's the company itself who is receiving the funds. Therefore, this investment increases the value of the company on a one-to-one basis. And it's also important to note, does a new share subscription, a new equity raise, increase value to existing shareholders? Well, the answer is no. Although the company receives money and its value increases, the existing shareholders get diluted. In other words, their percentages decrease and the value of their equity remains the same. So it's a value neutral transaction, assuming it's sold at fair market value from the perspective of an existing shareholder. The company is worth more because of the new funds, but you have a lower percentage ownership in the company such that those two factors offset and your economic position stays the same. And very, very simple example. We tried to keep it real easy. We had this in our report of pre-money, post-money value. And I won't go through this in too much detail, but assume you have a gentleman, Steve, who owns 100% of a piggy bank that has $10 in it. Steve's friend Mary is interested in buying the piggy bank, but Steve says, well, instead of buying it, why don't you contribute some new capital, subscribe for some new shares. If you put in $10, I will give you a 50% share, or you will be able to earn via the purchase of new shares in the piggy bank, a 50% share of the piggy bank. And what that leads to is a situation where Mary puts in her $10, that increases the value of the piggy bank from $10 to $20, and Steve and Mary then each have a 50% share. So the pre-money value of the piggy bank is just $10. That's what was in there before any transaction occurred. The post-money value of the piggy bank after Mary puts in the $10 is 20. 10 plus 10 is 20. But importantly, Steve's investment, the original investor, his investment's only ever worth $10. He either owns 100% of the pre-money value or 50% of the post-money value. So this is just a very simple example of how pre-money and post-money works. Turning to the specifics then of this case, what did this look like with respect to the February 2017 Interjects offer? Well, in step one, claimants are owners of 100% of CHM, which had a pre-money value of $9.773 million. That includes the $930,000 of future investment that claimants had yet to make. But that's the pre-money value, and claimants were 100% owners. In step two, Interjects would inject $17.8 million in cash into CHM in exchange for new shares, and would also separately pay $1.5 million to claimants as I think they called it a development fee or a development premium. And in exchange, Interjects would receive 40 million new shares representing 70% of the company. But as you see at the bottom of this sort of middle portion of the chart, again, that 17.8 million that Interjects puts into the company, it increases the value of the company because it's cash that's coming in. So where then does that leave the two parties on a post-money basis? Well, that leaves CHM has a value of 27.576 million, including this new investment, the original pre-money value plus the new money that was put in, of which Interjects owns 70% and claimants own 30%. And then claimants, as you can see on the side, also have that $1.5 million they got separately from Interjects as a development fee. So we can look at what this means for the value of claimants' investments both ways. What was their value before the transaction? What was their value after the transaction? And as we said it should be, the value of claimants' investment is exactly the same at $8.843 million, both before and after the Interjects transaction. Doesn't matter which way you look at this. Before the transaction, Interjects recognized development costs that claimants had put into the project of $7.63 million. They paid or were willing to pay a development premium for 100% of the project, equivalent to $2.14 million. That gives you a total pre-money value of that 9.773. You subtract the remaining investment that claimants had yet to make, that they would have had to make before Interjects put in the money, and that leaves you a net of 8.843 million. So that's the pre-money perspective of what this was worth, what claimants' investments were worth. Well, now let's look at it from a post-money basis. Here we start with, well, what was Interjects willing to spend to earn, to buy into 70% of this project on a post-money basis? Interjects would put in $17.8 million. They would pay a $1.5 million development premium. So in total, Interjects will have spent $19.3 million to earn a 70% ownership stake in the post-money version of CHM. And again, here you can calculate by dividing 19.3 divided by 70%, you get a 27.6 million post-money value, of which claimants at that point would only own 30%. And that then gives them a value of their stake of 8.273, to which you add the development premium and subtract the remaining investment and get the same number, 8.843 million. So whichever way you look at this, before or after the transaction, you get to the same result. And in fact, this is pretty similar to what we later see, which are 4 offers to purchase 100% of claimants' interest in CHM from both claimants made offers to sell, Interjects and Glenfarne made offers to buy, and all of these offers were in a range of $7 to $8.1 million, which is pretty similar to that Interjects offer from Feb 2017. And again, importantly, all 4 of these offers were based on the same fundamental conditions as in the but-for scenario, which we list here and which I believe was acknowledged yesterday by BRG in its testimony. So how does BRG get this so wrong? How do they say it's worth $27 million instead of 7 to 9? Well, they forget and they don't realize that the value of CHM would increase by 17.8 million only after those funds are invested into the company. BRG wrongly includes this nearly $18 million new investment as part of CHM's value as of March 2017. That is simply wrong. As of March 2017, CHM's value should not include $18 million for a planned future cash injection. That is just incorrect. And in fact, we would say that that approach is grossly incorrect and illogical. And here's a simple example to show you the flaw in this logic. Imagine an investor comes to you and says, I own a gold mine. I've done some feasibility studies. I have the rights to the concession, but that's where it stands. And there's a new investor who's planning to invest and spend $1 billion developing this gold mine, and he'll earn a equity share in the company by doing so. And according to BRG, what that person should say is, therefore, I currently own a $1 billion gold mine. That argument is nonsensical. The fact that someone eventually may put in $1 billion or $18 million that may increase the value of the company, but that doesn't change what the company is worth today before that money is invested. So again, we would say, just based on all this evidence, it's clear that the value of CHM and claimants investments implied by these offers is in that $7 to $9 million range. And if that weren't all, what we also have is Interjects' own financial model that they use to evaluate this project. This is a contemporaneous third-party analysis of the value in the but-for scenario. It includes a forecast of free cash flows to equity, and it specifies a discount rate, not a hurdle rate. I don't believe it says hurdle rate anywhere in that model. It says discount rate. It specifies a discount rate of 8%. And if you discount those free cash flows at that 8% discount rate, you get an implied DCF value of $7.231 million. Again, consistent with our view of these transactions and extremely inconsistent with BRG's view. And here on slide 16, we just have a comparison of all these various offers and analyses, which show that they're all in this tight range and they are generally consistent with our DCF and extremely inconsistent with BRG's DCF valuation, which in our view demonstrates that our analysis is correct and BRG's DCF analysis is not. And now turning to the DCF valuation, I'll hand things over to my colleague, Mr. Square.
Thank you, Mr. Sharp, and good morning and good afternoon to the members of the tribunal. As Mr. Sharp explained, both sets of experts agree that the DCF method is an acceptable method to value the project, but our valuation conclusions are very different. Next slide. So BRG calculates a fair market value for the project of $31.75 million as of March 2017. We conclude that this value is 4 times what it should be, or it is inflated by roughly 300%, as you see in the box to the right. And there are 5 reasons that explain this overvaluation, which we've listed here on the slide. I will cover the first 2, the cost of equity and the performance bond, and then Mr. Sharp will cover the next 3, which relate to the actual cost offsets and the modeling of construction costs and sales revenues. But when you correct for these 5 issues, the DCF value of the project changes to $7.5 million, which is right in line with the value that's implied by the Interjects offer that Mr. Sharp just explained. In the following slides, I will address the cost of equity issue first, which is the most significant issue impacting value. Now, before we unpack the details of BRG's cost of equity calculation, there is a simple test you could run to see whether BRG's cost of equity is right or wrong. And that is simply comparing the project's cost of debt with BRG's cost of equity. Now, the tribunal would have heard 2 terms used to describe cost of equity. One is the unlevered cost of equity, which implies the cost of equity when the project has no debt or it's debt-free. And the second is the levered cost of equity, which is the cost of equity when the project has taken on debt. But regardless of whether you're talking about unlevered cost of equity or the levered cost of equity, that cost of equity is always higher than the cost of debt. And I'll explain this with a simple example. Assume that you have a project that is debt-free, that's unlevered, and it's an early stage project, and you now have a $1 million debt investment coming into the project. Now, the project has a firm legal obligation to repay that debt with interest within a specified time frame. Now, in the alternative, instead of that debt investment, let's assume you now have an equity investment of $1 million that is flowing into this debt-free project. Now, in this case, the project has no obligation to repay that equity, nor is there any obligation to pay dividends on the equity. That equity for this project is therefore more risky than the debt. And the cost of this equity, this unlevered cost of equity, is therefore higher than the cost of debt. And this is a fundamental financial principle. We've explained this in detail in section 3A of our second report. I invite the tribunal to take a look at that. But it's important to understand that this distinction between levered and unlevered cost of equity makes no difference when you evaluate whether it should be higher or lower than the cost of debt. Now, if you go to the next slide, we show some numbers here. So the project cost of debt, which both experts agree is in the range of 7.1 to 7.36%, is, as you can see here, higher than BRG's unlevered cost of equity of 5.79%. So this is plainly incorrect. And yesterday we heard BRG sidestep and confuse this issue. They said this is a comparison of apples and oranges. This is not an apples and oranges comparison. This is corporate finance 101, as you can see via the quotes we have on the right. Now I'll just go through the first two. The first quote says the cost of debt is always less than the cost of equity. It does not matter whether it's a levered cost of equity or an unlevered cost of equity. The second quote, the second box is a question posed by Dr. Modron. The question is clear. It says, can the cost of equity ever be lower than the cost of debt for any firm at any stage in its life cycle? And the answer is no. Equity investors are always behind lenders in line for cash flows. So this could not be more clear. It doesn't matter whether the project is in a concept stage, construction stage, operation stage, whether it's levered or unlevered, that cost of equity will always be higher than the cost of debt. And it is surprising to me that the experts have a disagreement on this issue. It's also somewhat troubling. We can have a debate about what the cost of equity should be, but there should be no debate that the unlevered cost of equity has to be higher than the cost of debt. So in my view, this is a black and white issue, and BRG is dead wrong about this, but it's an important issue, and I welcome questions on this, either on cross-examination or from the tribunal. Next slide. So the logical question to ask is, having established that BRG's unlevered cost of equity is too low, the question is, why is it so low? And in order to understand that, we've got to look at the inputs to the CAPM formula that both experts use to calculate the cost of equity. And we've listed the buildup of the cost of equity calculation here. And we have a disagreement with BRG on three inputs, which we've shaded at the top. And we believe that BRG's values for each of these inputs is too low. And when you correct for these inputs, the unlevered cost of equity increases to 7.48%, which is above the cost of debt. So I will sequentially address each of these inputs in the following slides. Next slide. So the first input is the risk-free rate. And both experts rely on the yields on the 10-year US Treasury bonds to establish the risk-free rate. The disagreement is the duration over which this yield should be measured. We use the prevailing yield as of the valuation date, 14th March 2017, which is 2.6%. But BRG takes a trailing 12-month average yield for the 12 months prior to the valuation date, which gives them a risk-free rate of 1.94%. Now, in our reports, we've cited to numerous authorities which explain that the risk-free rate should be based on the prevailing rate, prevailing expectations as of the valuation date, which is what we have done. Now, BRG says that we are using an arbitrary date where the risk-free rate was artificially high, but this is simply incorrect. That date is not arbitrary. We are using the valuation date to set the risk-free rate. And BRG also has a defense saying that the risk-free rate was on a downward market trend as of the valuation date. This is also incorrect. And you can see this on the chart to the right. The vertical dotted black line is the valuation date. And you can see that in the run-up to the valuation date, the yields were generally increasing. But more importantly, as of the valuation date, you can see that dotted blue line, which shows that the expectation for rates going forward were actually increasing and not decreasing. And therefore, we believe our risk-free rate is reasonable, if not conservative, and BRG's risk-free rate is too low. Next slide. The second input we disagree on is the beta, which measures the volatility in the project's price or value relative to the market. And here, both experts again agree that we need to look at a peer group of publicly traded companies to measure this unlevered beta, but we disagree on what the peer group should be. So BRG relies on 52 companies in the US power sector, and these are all integrated power companies that are primarily focused on transmission and distribution, not on generation, and they have minimal, if any, hydroelectric power generation. We rely instead on 12 companies that operate in the Latin American market, and they have a high focus on generation, and within generation, on hydropower generation. So we believe that is a better peer group that gives us a reliable estimate of beta. And you can also do a reasonableness check. We have here a company, which is a subsidiary of Enel called Edegel. It's the largest electricity generator in Peru. And the analysts value this company on an ongoing basis. And they use an unlevered beta of 0.62 for this company, which is slightly higher than our unlevered beta, which again shows that our beta is reasonable, if not conservative. Next slide. And here we drill down a little more into the peer group of companies that we use. And you can see here that all of our companies have operations in Latin America. They have significant hydropower generation assets, whereas in BRG's peer set, there are no companies with operations in Latin America and very few companies that have any significant hydropower generation. So again, we maintain that our peer group is a better peer group and gives you a reliable estimate of beta. Next slide. The third input we disagree on is the equity risk premium, or the ERP. And we use an ERP of 5.5%, which is based on current premiums, meaning expectations as of the valuation date, based on guidance provided by Professors De Modron and Fernandez and Duff Phelps. BRG uses a historic average premium over a 80 or 90-year period and uses a geometric mean for this data to calculate a ERP of 4.62% based on data published by Professor De Modron. Now, the problem with BRG's method is that Professor De Modron himself states that reliance on such long-run historical averages is not reliable. It's an inferior method because it's a poor predictor of expectations and movements going forward. Another way to test whether the BRG ERP is reasonable is to look at the total market return, which is the sum of the risk-free rate and the ERP. And we've charted that on the graph to the right. And you can see when you add the risk-free rate and the ERP, the total return that BRG calculates is 6.56%, which is towards the very low end of the range that we see of benchmarks here. And our estimate is 8.1%, which is more in line with the consensus view here, which is in the 8 to 9% range. So again, we believe that our ERP is reasonable and BRG's ERP is too low. Next slide. So we've so far been looking at a bottom-up analysis of all of the inputs that give us the cost of equity. But you could also look at this top-down by comparing BRG's cost of equity and our cost of equity with other benchmarks for cost of equity that are in the record. And that's what we have done on this slide. The red bar shows you BRG's cost of equity over the life of the project. The blue bar shows our estimate of the cost of equity over the life of the project. And the three green bars are benchmarks we have. The first one is Interjects' discount rate, which is 8%. And the next two green bars show you the cost of equity that have been calculated by analysts covering the two largest electricity generators in Peru. These are diversified generators with hydropower operations, and they calculate costs of equity of above 9% for both these companies. So this again shows that the cost of equity that we calculate is reasonable, if not conservative, and BRG's cost of equity is too low. Next slide. So in this slide, we show you the impact of correcting each of the three inputs that I just discussed. So if you start with BRG's valuation on the far left, which is the red bar, 31.75 million, and you progressively correct for the risk-free rate, the equity risk premium, and the unlevered beta, the corrected DCF value drops 15.7 million, which is roughly a 50% reduction in value. So you can clearly see this is a significant factor impacting the valuation. Next slide. So now the second area of disagreement is the performance bond. And here what we disagree with is the way in which BRG models this in the but-for scenario versus the actual scenario, because they are not consistent. So in the but-for scenario, in its DCF valuation, BRG assumes that the cash collateral of 5 million that was provided for the performance bond would be released, which is a fair assumption. We agree with that. But in the actual scenario, they assume that that 5 million would not be released. But this is an incorrect assumption because in reality, this performance bond has not been executed to date, nor will it be executed if claimants prevail on their claims. Therefore, if claimants prevail, BRG would claim the 5 million via the DCF valuation but then claimants would also receive the cash released from the performance bond of 5 million to get a total of 10 million, which will result in a windfall to claimants. Now, BRG appears to acknowledge this in their second report, where they say that if the performance bonds are released, they would reserve the right to update their analysis, but they've not done this as yet. So their analysis as it currently stands captures this additional 5 million value into the DCF model, which has a net effect of a 4 million increase in their DCF value. I'll now turn it back to Mr. Shop, who will cover the remaining areas of disagreement.
Thank you. So the third difference in our DCF models relates to the so-called actual cost offset. What this means is that BRG offsets the budgeted project construction costs. So in other words, the costs that had to be incurred to get the project up and running. BRG reduces those costs, which are negatives in the DCF, by the amount that claimants spent from March 2017 to December 2018, so after the valuation date. And in doing so, BRG increases its DCF value by roughly $7.1 million based on actual costs in this sort of March 2017 to December 2018 period. And while we agree sort of in principle that if these costs truly did reduce the budgeted costs, then it could be appropriate to include them in this damages calculation. However, we would say that only those costs that serve to actually reduce the budgeted costs should be included as an offset. So if they are over budget or if they weren't in the budget to begin with, then you can't say that they are reducing something that was in the budget that you're using to construct your DCF. And having looked at the budgeted expenditures versus these actual expenditures, categorizing them to the best of our ability based on the information we had, we determined that at most 4.3 million of these costs were included in the project budget and should be considered or could be considered as an offset. However, as we'll discuss later, we think that anything that's reliant on claimants' costs summaries is somewhat questionable due to discrepancies between their alleged costs and the underlying support that has been provided by claimants. So this is truly an at most number in our view. Fourth, getting into some more minor issues now, BRG miscalculates the timing and amount of construction costs. For the timing, BRG relies on a generic method, which evenly spreads all costs over the 30.3 month remaining construction period. We rely on the specific cost allocation schedule as set out in the Hatch report, and we think that's a better method. Similarly, the access road contingency cost, this access road was the most significant construction risk according to the various engineers and technical evaluators. But the 2017 Hatch report is the only source with a specific estimate of this access road contingency. And we would say that because this is really the only specific source, it's the best source, and it contains a specific contingency of 1.316 million, which we apply. And we think that's preferable to BRG's approach, which relies on a generic civil and additional works contingency, sort of this categorical contingency percentage that BRG applies to just the access road. And they use that to come up with an estimate of roughly 0.4 million for this contingency cost. And fifth and finally, BRG overestimates electricity prices and sales revenues. These are relatively minor, so I won't go into detail too much. I invite you to read our reports where we've discussed these at length. But first, BRG ignores the asymmetrical price penalty in the RAR contract, in which the prices are reduced in years, we call them dry years, when CHM produces less than 130,000 megawatt hours. There's no corresponding price increase if they produce more than the 130 benchmark. So that translates to, according to our detailed calculations, a 1.9% average reduction over the life of the contract. And second, BRG assumes that the RAR contract end date is extended from 2036 to 2039 based on legal instruction from its counsel. We understand from our counsel that there is no legal basis to assume that this contract extension would have occurred. So where does that leave us? Here's a chart that shows starting with BRG's total, so FMV as of March 2017 value of $31.75 million, making these corrections, including the cost of equity, performance bond, and so on. When these corrections are made, you reach a value of $7.519 million, which we say is the correct amount, and again, is in line with the value implied by all the offers for claimants' investments. So in addition to that, there's also what's been called damages for alleged additional costs. BRG adds $2.4 million for these additional costs and expenses, which were incurred starting in January 2019. And these include things like the costs of the Lima arbitration, costs of criminal defense that were incurred by the company, cost of dismantling operations, so on and so forth. We offer no opinion on the appropriateness of these costs having been incurred or the legal viability of the damages claim. So we just include this in our analysis, but understand that it is in dispute between the parties whether this is a relevant damages figure. And we would just again note that this 2.4 million number is based on these summary accounting spreadsheets provided by claimants. But as we'll discuss in a later section, we find multiple issues with claimants' cost documentation, which calls into question, in our view, the reliability of this claim for $2.4 million. Turning then to pre-award interest and the damages conclusion. BRG calculates pre-award interest based on the project's cost of debt of 7.06%. Well, this cost of debt for the project was higher than junk bond rates due to its overall high level of risk. And in our view, and as discussed by numerous authors on the topic, which we've quoted some of them on the right, it is economically illogical to award claimants extra compensation via pre-award interest for undertaking, but not having been required to successfully complete a high-risk project. In other words, you should not reward the claimant for a risk that they never took, in particular when it's a very high risk. And we calculate as an alternative what we consider to be three economically rational potential pre-award interest rates, which range from 2.3 to 3.4%. These include Respondents' USD denominated government bond rate under the forced loan theory that claimant should receive the same rate of return as other lenders to Respondent. We include the yield on investment grade corporate bonds as a proxy for a normal commercially reasonable rate. And finally, under the risk-free rate theory, under which claimant should only be compensated for the time value of money, we calculate pre-award interest based on the yield on US Treasury bonds. And in our view, again, these are economically rational rates that do not reward claimants via pre-award interest simply because the project was high risk. Where does this leave us? We have nominal FMV damages totaling 9.931 million, as you can see in the table, comprised of 7.5 million as what we call the but-for value as of March 17, 2.4 million in additional costs and expenses. And to those amounts, we add pre-award interest calculated based on these three economically rational potential rates, ranging from 0.9 to 1.4 million. And that results in total FMV damages as of 1 March 2022 of 10.827 to $11.284 million. Now, very briefly on sunk costs, which was discussed a bit yesterday. Here, there is agreement between the experts that sunk costs do not represent the fair market value of claimants' investments. And therefore, if the appropriate standard of compensation is the fair market value of claimants' investments, then sunk costs or the so-called investment value damages calculation are irrelevant because they don't measure FMV. And that's because sunk costs could be higher than fair market value, for instance, if there was overspending, or it could be lower than fair market value, for instance, if there were positive market project-specific developments. But in any case, If the goal here is fair market value, sunk costs isn't something that works. We'd also note that claimant sunk costs remain unsupported. BRG has calculated 26.678 million in sunk costs, which we are summarized in this table to the right, based on accounting summary spreadsheets prepared by the claimants. And while BRG says that these supporting documents, which is basically a 1,400-page PDF that claimants produced at one point, while BRG says that those supporting documents validate all expenses incurred by claimants, they performed absolutely no analysis of this issue whatsoever, nor, as far as we're aware, was any analysis of this type of validation exercise presented by Mr. Sillen. We heard yesterday that he had performed a reconciliation, but I don't believe we've seen any such reconciliation. We did do a detailed analysis of this 1,400-page PDF, and in an attempt to compare what claimants say the costs were in their Excel spreadsheet versus what the underlying documents can support. And our analysis shows that nearly half of the alleged sunk costs remain unsupported. We talk about this in our report. It's sort of summarized, some of the issues are summarized here in the table to the right. But what this means at the end of the day, in our view, this is further sort of evidence information that sunk costs would not be reliable even as an alternative damages remedy. And finally, even ignoring all of that, all of the reliability concerns and the fact that it doesn't approximate FMV, even if you were to go to sunk costs still, there are still a minimum of 3 necessary corrections to BRG's calculation. We show them here. First, remove the performance bond guarantee for the reasons Mr. Sequeira discussed. Second, remove the upstream project costs on the basis that those were, we understand, unaffected by the breaches. And third, apply a lower pre-award interest rate at the rates we discussed earlier. And what that would leave you with is total sunk costs with interest through March 2022, ranging from $23.5 to $25.1 million in damages. And that concludes our presentation. We thank you again for the opportunity to discuss with you today, and we're happy to answer any questions you might have.
Before we move to the cross-examination, I have one question, Mr. Shop. That is the last section where you address sunk costs, and where you state I agree with the BRG that sunk costs do not represent FMV, the fair market value investment, but could they represent damages in general?
I think that may be more of an issue for you to decide. I think we would say that if the goal is FMV, sunk costs don't necessarily approximate it. I think.
Yeah, I do understand, but the theory being, I've spent, according to you, corrected, what is it, depending where you look at, from 25 to 23 million, corrected. I spent this, and in any case, whatever maybe else about valuations and what you have, that I spent, and I want my money back, if in case there's a breach.
If the theory is that compensation should be give them their money back with interest, as opposed to they're entitled to the value of their investment at the time of the deprivation or the expropriation, then sunk costs could be appropriate as damages in that context. Again, I think we would caution that there are some reliability concerns about these numbers, but yes, that could be an appropriate damages remedy if the idea is to just give them back any money that they put into the investment, rather than focusing on what the investment is worth.
Yeah, I raised this point because most of these fair market value evaluations are done in the context of expropriation claims, sometimes also in FET claims, as they call it, fair and equitable treatment treaty claims. If you're under contract analysis, there are various theories for what you call damages, and so in that context. But apparently, you have not been instructed to do that.
No, we have not.
And it may also not be a matter in this arbitration. All right. Thank you, Mr. Shop. Mr. Zeballos, please proceed.
Yes, I'm ready to move forward, Mr. President.
In the meantime, we received another CD05 from you.
Yes.
Okay, all right. You're going to use that?
Yes, I am going to use that today.
Okay. Please proceed.
Can I please respectfully ask for people to remember the 3 or 5 second rule today?
Sure. Okay.
I will do my best. I'm a Chilean raised in New York, so it's a tall order to ask me to speak more slowly, but I will do my best to honor that.
Good.
Good morning, Mr. Shop.
Good morning.
Good morning, Mr. Sequeira.
Good morning, Council.
I'm going to address my questions to Mr. Shop primarily, just as we did yesterday. If you feel that your colleague, Mr. Shop, is more appropriate to answer the question, just indicate that. It's not going to be an issue for me. You've prepared 2 reports for these proceedings, right, Mr. Shop?
That's correct.
And those reports provide 2 alternate damages approaches, correct?
Not sure to what you're referring.
Well, one of your approaches is a DCF analysis for damages, correct?
One of the approaches is what I would maybe term fair market value as opposed to DCF.
Okay, but your fair market value analysis uses a DCF approach, correct?
As part of it, also the implied value from the offers.
Okay, and the other approach you use, Mr. Shop, is a sunk cost analysis, right?
I wouldn't say we use that approach. BRG presented that as what I understand, claimants presented as an alternative damages remedy called, they referred to it as investment value. So I wouldn't say that we presented that as a damages approach. That was responding to what BRG, apparently based on instruction, proposed as an alternative damages remedy.
Okay, but you agree that the DCF approach is the appropriate means to determine the value of the Mamacocha project, correct?
Yeah, I mean, the DCF approach is applicable here in our view under this sort of fair market value damages approach. That's right.
And your DCF analysis relies on a valuation date of March 14th, 2017, right?
Correct.
Okay. And you assessed damages in your DCF analysis as of that date, correct?
Yes and no, because BRG introduced this actual cost offset point. We are, of course, looking at costs that claimant incurred through December 2018 as sort of part of that DCF. But generally speaking, the idea is to assess the value as of March 2017.
And the information you considered for your DCF analysis was information that existed on or before that date, right?
That should be the case. Yeah, I believe so.
And Mr. Shop, do you confirm that any documents material to your conclusion are attached to or referenced in your report?
Yes, that should be the case.
Okay, and if you didn't attach or refer to documents in your reports, it's because they aren't material to the conclusions you reached in your report.
Not material enough that they were directly relevant to a footnote or something we were citing. I mean, certainly we reviewed more documents than we cited in our reports. But I would say the most material ones, or everything we've cited is material, and the most material, that should include the most material ones, but not all that we reviewed.
Okay, and you don't use the word amparo anywhere in your first report at all, do you?
That's testing my memory. I'll take your word for it. If you say
I'll represent to you that
okay.
I ran a word search and that it doesn't appear. That's a reasonable response, Mr. Shaw. And in your second report, the word amparo, I'll represent to you that I ran a word search in your second report, and the word amparo appears only in one footnote, footnote 79.
That may be the case.
Okay. I'd like to take you to paragraph 16 of your first report. Can you put that up on the screen, Tom? Okay. in this paragraph, you describe BRG's approach to fair market damages as described, in this paragraph, you describe BRG's approach to fair market damages as comprised of two elements. One is BRG's estimate of the value of the project, and two is claimant's actual costs. Is that right?
That's right. That's not how BRG presented it. They didn't sort of split things exactly that way, but we split them here in that manner.
Okay. And in your second report, you also consider the fair market value of the project on the valuation date and claimant's actual costs, right?
We'd have to look, and I guess actual costs meaning the additional costs and expenses or this cost offset piece.
Well, let's pull up Appendix M of your second report.
Sure.
Okay, let's focus on line 10. Do you see where it says but for?
Yeah, that's excluding this actual cost offset, which is the next line down.
Right, and the but for refers to the fair market value on the valuation date, correct?
That's right, before accounting for any of these additional costs claimants had incurred over that March 2017 to December 2018 period.
Okay. And the figure in cell F10 is $3.402 million, correct?
That's correct.
And that's the result your DCF model provided, correct?
That's right.
Okay. And that constitutes your estimate of the fair market value of the project on March 14th, 2017, based on your DCF methodology, correct?
Correct.
Mr. Shop, your piggy bank hypothetical that you just described, in that hypothetical, your piggy bank doesn't generate any revenue, does it?
Well, you could take money out of the piggy bank. That would be generating revenue. It's not a business, if that's what you mean.
Yeah.
But I could reach into a piggy bank, take out $1, and that would be revenue generation of the sort. It's something that has cash and can generate cash at its simplest level.
But this isn't a piggy bank that makes money, right? It doesn't print dollars, does it?
No, I would like to have that kind of piggy bank.
All right, I'd like to walk you through a hypothetical, Mr. Shop. My hypothetical is a revenue producing project, okay?
Sure.
Okay, and this revenue producing project in my hypothetical is a farm, okay? And in year one, I have $10 million in costs, and this includes all my costs, seeds, et cetera, everything I need, okay? Are you following me?
Yes.
Okay. In year two, I have my harvest. And I also have a guaranteed buyer that will guarantee me $100 million in income net of costs. So far, so good?
Yes.
Okay. So I'd like to run a fair market value analysis using the DCF method of my project. All right. And we're going to assume no externalities, no inflation, no completion risk, no other impacts. We're going to keep this very simple, okay? And for the sake of simplicity, let's assume a discount rate of 10%, okay?
Okay.
Okay, so on day one, the value of my farm project will be $80 million, which is my income discounted by 10% to 90 million and subtracting my $10 million costs, right?
Yes, that sounds right.
Okay, so the farm is worth $80 million on day one, even though the harvest isn't until year two, correct?
Correct. That's the premise of DCF valuation for an early stage project.
Okay, let's change the hypothetical a little bit. Let's assume I have the money to develop the farm on my own, but you and we agree to be 50-50 partners, okay? And again, no externalities, nothing to suggest that you won't invest. So there's certainty that you and I are going to invest in this project together, okay?
Okay.
And now the only change to my hypothetical is our partnership. Everything else we've discussed remains the same. The fair value of the farm in my hypothetical partnership, it would still be $80 million, right?
Yes, we could reach, I suppose if you agreed to sell me half of your farm for $5 million, that would probably call into question your alleged DCF value. But yes, adding a new investor does not fundamentally change the value of the investment before that investor comes in. That's what we said earlier. Pre-money value is pre-money value. It's only new investment that adds to the value of the business.
And so my $80 million farm, that's the value of my farm, even though I've only invested $5 million and you've only invested $5 million. The fair market value of my farm on day one remains $80 million, just as it has in every other scenario I've given you.
Yeah, I mean, I would agree with that hypothetical. I don't think it really goes to the issue at hand here, but I do agree with that hypothetical.
And my 50% share in that farm is $40 million, right? It's worth $40 million.
If I had agreed to buy 50% from you for $40 million, I think you could reasonably say that your share is worth $40 million. Okay. On the DCF basis, that might be what you come up with as well.
Right. And the fair market value of both equity stakes together, in other words, of 100%, remains $80 million, right? I think you just said that.
Yeah.
Okay. And that value wouldn't change if I was thinking of selling my interest, right?
No, not from thinking of selling. When it would change if I, as this new investor, came in and actually spent $5 million, because then we would not have 10 million in expenses in year one. Instead, we would only have a net of 5, because I would have at that point increased the value of the company by spending money.
And the value of my $80 million farm wouldn't change if you were thinking of selling your 50% share, would it?
Thinking of something, no.
Okay. Give me 1 second. Okay, let's make one last alteration to my hypothetical. Let's say at the last minute, you pull out of my project unexpectedly, but I want to go forward. But remember, I can still put up the other $5 million. So I put up the rest of the money. And the project goes forward, okay? In that hypothetical, my farm is still worth $80 million on day one, right?
Yeah, pre-money value is pre-money value. The farm is worth what it's worth before a new investor comes in. Again, I as a concept, I agree with you.
Okay, and it wouldn't make any difference that perhaps we'd only ever conceived of it as a 50-50 partnership between the two of us. As long as the project goes forward, the value of a 100% equity stake in the project remains $80 million on day one, correct?
Yeah, that's right.
Right. And in the hypothetical I just gave you, we calculate the fair market value of the farm by applying a DCF analysis to the projected future cash flows of the farm, correct?
That's how you did it in your hypothetical. As I mentioned, if you had offered to sell me the farm or 50% of the farm for $5 million, I think we could reasonably say it's probably not worth 80 at that point. So yes, you could have a DCF. DCFs come up with lots of different results based on different inputs, as we see here. But in your hypothetical, you only talked about the DCF. If we had an offer, as we do here, obviously we would want to consider that as well.
Okay. Your DCF model of the Mamacocha project relies on projected future cash flows from that project, correct?
Correct. Both negative in the early years for construction and debt repayment, and then positive through revenue generation.
Right. And your model applies a DCF methodology to those future cash flows to determine fair market value, right?
We discount the future cash flows to equity to determine the value, yes. Excuse me.
Perdón que aproveche para interrumpir. Les podría pedir a los participantes que hablen un poquito más despacio, que dejen una pequeña pausa entre la pregunta y respuesta para la interpretación. Gracias.
Por supuesto, lo siento. Okay. Let's pull up. Oh, do we still have Appendix M up on the screen here? Okay, that's good. That's where I was going next. So let's just keep that up here. So just so that we're clear, I think we've established that you conclude that your DCF value of the project representing the fair market value of the project on March 14th, 2017 is 3.402 million. So let's focus on the next line, which is the 4.117 million. And the 4.117 million represents actual costs and expenditures incurred in the project, and as we discussed earlier today, isn't that right?
It represents, based on our analysis, the portion of the costs incurred by claimants from March 2017 to December 2018 that offset or were within the project's budget that's included in the DCF. It's not all of the costs they incurred according to their summary spreadsheets, but it is a subset of those.
Okay, so let's pull up slide 4 of your presentation from this morning. Okay. And you see the line where it says fair market value of claimants' investments as of 14 March 2017, and you have the number 7.5.
Yes, I see that.
Yes, now that number combines the fair market value, which we just looked at, the 3.4 million, plus the 4 million and change from the actual costs and expenditures, correct?
That's right, and this is simply following BRG's approach. You could look at table 1 of their second report, where they have what they call the but-for value of the Mamacocha project as of 14 March 2017 and list 31.75 million. So we're not trying to hide this. This is literally using BRG's exact same format for demonstrating these numbers. So we're happy to split it further if you think that would be useful.
Yes, Mr. Shop, I'm just trying to make, I think what you mean to say here is, as you have this caption, it shouldn't say fair market value of claimant's investment. It should say damages based on fair market value methodology or DCF methodology or however you want to say, but it's a combination of fair market value and actual costs, but the fair market value component of it, as we've just established, is 3.4. That's correct, right?
Yeah, the DCF itself, excluding the sort of actual cost offset, produces 3.4 million. That's right.
Okay. Let's take a look at your assessment of actual costs. Please turn to paragraph 80 of your second report. Tom, if you could put that up, please. And Mr. Shop, if at any time I'm referring to a paragraph or page in your report and I forget to pull it up, feel free to interrupt me to ask me to pull the document up.
I have a hard copy of the reports here as well.
While there's a quick pause, Mr. Shop, you're doing great, but I want to remind you the interpreters have to finish his question interpreting. So if you pause before you answer, it's so much help. Thank you.
I will make an effort to do that. I apologize.
Now, the $4.285 million referenced here, I'm going to refer to this as $4 million simply because I know that there's some adjustment with the DCF. When you run these numbers, they might change marginally. So I'm not trying to trip you up on that difference. I'm just going to say 4 million. If you want me to be more precise, you can say so. But this $4 million in actual costs, you didn't include any of those actual costs in your first report, right?
No, and as we explained in our first report, BRG really didn't say why they were doing this offset. It wasn't clear to us if this was sort of just a cost claim added to the DCF, or what we later found out that they viewed it as an offset to construction costs. Again, it was a little unclear why costs such as these would be considered in what BRG called the but-for value as of March 2017. So we discussed them. We didn't ignore those costs and how they were incorporated. We sort of asked for clarification. BRG provided it, and we proceeded on that basis in our second report.
Okay, and the actual costs that you do include in your second report, and again, I'm going to use a rounding figure here, but are about $2.5 million less than the actual costs that BRG includes in its second report, right?
That's right. I think it's, let's call it 4 versus 6.5, I think is pretty close.
Sure. Okay, let's turn to paragraph 79 in your second report. Okay. And you exclude this $2.5 million or so on the grounds that they were either over budget or not included in the budget at all, correct?
That's right. The idea is that if your DCF has a budget and the premise is that you are sort of avoiding having to incur those costs that are in the budget because they've already been spent by claimants at a subsequent date, then it's necessary that they're included in the budget. If it's over budget, then, well, it turns out your budget was too low and should have been higher. If they're not in the budget at all, then they, again, are just an extra cost that wasn't in the budget, and they can't be said to be an offset, as BRG termed it.
Okay, let's take a look at the construction budget, which is table 6 at page 37 of your second report. Okay. Now, this table shows a total construction budget of $7,314,534 and actual expenditures through December of 2018 of $7,084,513, correct?
That's right. And I would say this isn't the total construction budget. I believe, and we could, I don't know that we need to, we could turn to Appendix O. I think this may just be the project owner component of the construction budget, or some other subset that relates to this type of cost. But you are right, those two numbers are correct, 7.3 and 7.1 million.
Right, and so actual expenditures are lower than the total budgeted expenditure here, right?
Which is unsurprising given that they didn't actually start construction on the project. I would have expected them to be much lower still for that reason, but yes, it is lower.
Gentlemen, may I remind you the plea of the court reporters and the interpreters to take a number of seconds between Q&A. Thank you.
Yes, Mr. President. And your table 6 contains a number of subcategories. Technical employee, project administration, technical consulting, social, PR, et cetera, et cetera. Do you see those?
Yes, I do see those.
And are these categories that you identified or categories that claimants identified?
I'd have to check which of them match one-to-one. Essentially what we had is you have a budget that splits it in a certain way according to categories. And then you have a spreadsheet of hundreds, if not thousands, of different cost items, which we had some for, we had receipts or we had an invoice, which don't have obviously the same categories. You know, there's not some uniform categorization system. So the challenge here, and what was necessary, was to try to categorize both the budgeted and the actual expenditures according to some common system that was detailed enough to be meaningful, but not so detailed that it was thousands of rows, and then do a comparison on that basis. But I'd have to look at the budget to see which of these were exactly the same categories. I know we probably combined a few, or or maybe reworded it just for ease of comparison, given that we are looking at a budget, which is very nice and neatly organized, versus thousands of costs, which we have to sort of fit into one of those budget categories.
But Mr. Sharp, these are your categories, right? These are your team's categories.
Again, I assume the budget may say something like project admin, or it may have social, or it may have easements as a category. So we did do a categorization system. I think we tried to have them be corresponding where that was possible. I have to look at Appendix O and the budgets to see kind of which of these are direct overlaps of categories and which are ones where we had to sort of combine categories from the budget to make the best comparison we could based on the underlying expense data.
So based on your identification of these categories, I'm trying to understand what you're saying. If I misstate it, please correct me. But based on your understanding of the hundreds of thousands of line items that you saw, you tried to simplify this by putting it into these categories. Am I right so far?
That's right. I mean, Appendix O goes into this sort of exercise in some detail where we categorize each of the expense items. I don't know, it's hundreds of thousands, certainly hundreds of expense line items, and try to match that to an equivalent budget category.
Right.
And this is because when BRG did this exercise, they just said, claimant spent 7 million, that's an offset to construction costs. And we looked at it and said, well, a lot of these things appear to have nothing to do with construction costs, which again, stands to reason as construction hadn't started yet. And this was our attempt to say, okay, which of these could conceivably be included in the construction budget versus which ones are outside of or above the construction budget. But it was an exercise necessitated by the nature of the data to try to sort of fit the cost with a budget line item as best we could.
So you used your best judgment, for example, to determine what budget is, whether a line item fit was a technical employee or a technical consultant or a project admin. You guys were the ones who figured out whether that expense should go into that category?
To the best of our ability. I apologize for the lack of a pause. You know, we had invoices at times. You know, some of it is to an extent subjective, but again, it's all set out in detail in Appendix O of our report.
Okay, and the budgets, you know, where the column where you have budgeted expenditures and you have it divided by these categories. So then you used the same exercise to determine what the budget was for these categories as well, correct?
Correct. Again, I would refer you to Appendix O, which has all of this in detail, in sort of gory detail. It's quite a big appendix, I believe.
And then my same question for actual expenditures. So once you determined what the budget was, using the best of your ability, your best judgment to try to fit individual expenses into these budgets, you looked at the actual expenditures and did the same exercise to determine whether something was over or under budget, correct?
We categorized the different expenses, and then whether it's over or under budget just depends on what the sum for each category would have been. So we didn't look at an individual expense and say, is this over or under budget? We grouped and categorized all of the expenses, grouped and categorized the budget items, and compared them on a like-for-like basis as best we could. Again, because there's no sort of common categorization system that naturally exists for accounting line items, you know, there is no common, so we had to come up with something for that.
I see.
And again, that is documented in detail in our Appendix O.
I see. So let's take a look at the project administration line. This line, so this is way over budget. I mean, this shows $2.4 million if we round up, $2.4 million in actual expenditures, but only $700,000 in budgeted expenditures. So this is one of the worst line items from your perspective, right? This is way over budget.
I don't think I would say worst. It's one where I believe that's all the employees at sort of the corporate level who were in Miami, who continued to draw salaries and benefits, during this period, and relatively high salaries. And again, it's higher than what appeared to be the equivalent line item in the budget itself.
Mm-hmm. And then let's take a look at technical employees. So technical employees, the project was way under budget here. I mean, almost $1 million, actually over $1 million under budget here, right?
That's right. And that's, again, as I would expect, given that they hadn't actually started construction of the project. You would think that if you're not building a hydro plant, you're probably not going to be hiring too many technical employees at that point.
So if somebody is an engineer.
Mr. Ceballos, that is not 3 seconds. Please excuse me. I know it's so hard, and I'm sorry. I have to keep on you. I'm sorry.
Fair enough. So Mr. Shop, if somebody is an engineer, right, if their professional title is engineer, do you put them in technical employee, or do you put them in project administration, or do you put them in technical consulting? I mean, how do you decide that?
Again, I think maybe we could go to Appendix O. To the best of our ability, we looked at people's job titles. We had invoices from various people, payroll records. So we tried to, if it was clearly a line engineer, somebody who's at the plant day to day doing work, we would try to group them, I assume, with technical employee. If it was a sort of the equivalent of a hatch or a poirie who's doing consulting work, we would call that technical consulting. If it's somebody who we know was the CEO or the CFO or, some very high upper level management person who's not necessarily involved at the project level, they would have been grouped into project admin, or if it was, rent for an office in Miami again, or wherever. So again, this is looking at the individual expenses, trying to the best of our ability to categorize these expenses such that it can be compared with the budget. And again, we did for every line item, this was an extensive exercise. We did this for every line item expense as set out in detail in Appendix O.
So if you didn't know, you used your best judgment is what you're telling me.
Yes, again, because nobody before us had tried to do this. The assumption was, well, they spent it, so it must be an offset to the budget, when that, based on this, certainly appears to be unreasonable. And I think as a matter of kind of logic, that they hadn't actually started construction yet also seems to be reasonable.
And it's your position that that's more reasonable than simply using the construction budget. It's budgets that were produced to you that show that actual expenditures were less than budgeted expenditures.
Well, of course, actual expenditures were less than budgeted within a construction, but I mean, we are trying to give claimants credit for all the work they've done if it conceivably fell within one of these categories. So again, they had not started construction. They have management employees who are in Miami who presumably would have had to be there, had construction been ongoing. So we said, okay, that counts towards the budget. But $750,000 in legal fees, that's not something that's in the construction budget, as far as we could tell. So that's something that we would say shouldn't be in there. Or this apparent extra $1.6 million in project admin costs that is above what's in the budget. So we're not trying to compare the bottom line numbers, ignores what those costs actually are. That's our point. And that to say that it's an offset, it's reasonable and we think necessary to try to establish that it's a cost that actually is in the budget such that it can be an offset to the budget.
All right. We're almost done with this. I just want to move at focus. You just mentioned the legal expend. These legal expenditures, these include legal expenditures incurred by claimants in the real world, right?
That's right. I believe so, yes.
And claimants allege that these are legal expenditures undertaken because of the measures, right?
I don't know about these specific legal expenses. Claimants may make that allegation for this $753,000. I don't know.
Right, but I'm sorry, 3-second rule. But you don't dispute that those fees were incurred, right?
Well, there is an accounting summary spreadsheet that has those costs on it. In some cases, there are invoices which support those amounts. On a global basis, we do find that a lot of the costs are unsupported with that underlying detail, but there's a spreadsheet that says that those costs were incurred. That is true.
Okay, but you put them in this line item instead of project admin, so you did that for a reason, I would think, right?
Yeah, I think because they're identified as an invoice from a law firm, and yeah, I mean, we could have put them in project admin; they would have been similarly over budget. But yeah, they were specified as legal expenses because the line item in the spreadsheet says invoice from whatever law firm or whatever lawyer.
And a portion of the RER fees are also excluded here because they were supposedly over budget, correct?
Yeah, it appears that the budget had $250,000 over this roughly 1 year, 9-month period, but according again to these cost spreadsheets, there were roughly 78,000 worth of costs. So again, it appeared to be over budget based on that.
Right, and you don't dispute that those fees were incurred, right?
Again, they're in the spreadsheet. I don't know that we've seen a underlying document for those specifically, but this would be an example of where if you're calculating the DCF value based on a budget, and you say the budget's 250 grand, 250,000, and then it turns out that that cost is 477,000, and that's what you deduct or add under this actual cost offset. Well, that's wrong because your DCF budget was too low to start with. So you are overstating the but for FMV by that delta, by that $227,000. That's why if for this to be an offset, it has to offset a specific amount that it's included in the budget.
So when you removed actual expenditures from that additional cost analysis, did you account for them anywhere else in your report since they were actual expenses incurred by claimants?
No, I think, oh, sorry, I put
I'm
the pause. No.
Or did you just remove them altogether?
So we remove them from this valuation. We have a note, we say it twice, in which case these costs, if they're outside the budget, could be claimed separately as an additional cost if claimants can demonstrate they were caused by the alleged breaches. So we're not saying they just should disappear into the ether if there is a legal basis put forward by claimants for sort of recouping those costs, but to simply assume that, well, it was spent, therefore it should be recouped within the context of the DCF model makes no sense. It has to be something that adds to the value of the project as sort of envisioned in this but-for world. So if claimants can say there's 753,000 in legal fees, I can prove that that's the amount of them. I can prove that that total amount is strictly associated with the alleged breaches. And here's my new damages claim for that, just like is done with this additional costs and expenses of 2.412 million, which is a separate claim, then that could be appropriate. I mean, we acknowledge that in our report, but to simply assume without that level of even sort of allegation that these specific costs were caused by the breaches, at least that we're aware, BRG certainly didn't make any such link, then yeah, we remove them from the analysis. But acknowledge that if they are truly and directly and with support proved, due to the alleged breaches, then claimants could make a claim for them. And then we discuss that on its terms.
Mr. President, I think this would be a good place for a 15-minute break.
Good. Recess until 15:50 CET. Gentlemen, Mr. Shop and Mr. Sikiera, you're not allowed to discuss this case anyone because you're under testimony.
Yes, of course.
We confirm.
Everybody's accounted for. Mr. Bios, please continue the cross-examination and please be mindful of the 3-second rule.
Yes. Could you bear with me 1 second, Mr. President and Mr. Shop? My live note isn't working. I just need to reset it.
Okay. Sorry.
And if I may, if this is allowed, I don't know if it's a function of my failing eyesight or memory, but I referred to Appendix O when we were talking about.
Yeah, but before you do that, because I think Mr. Bios has an issue, a technical issue.
Okay.
Then please come back.
Mr. Shop, I think I know where you're going. It's Appendix Q.
That's right.
Just for the sake of the record, that there's an inadvertent error in the Version report. Version report 2, is it, or 2, or 1? 2. I'm sorry, 2. My team's correcting me. It's Version report 2. The appendix refers to Appendix O as support for the additional costs. It should be Appendix Q. We have no issue with it. That's an absolutely appropriate correction.
Mr. Bios, you have overcome your technical.
Yes, I have. Thank you.
Online, literally. All right. Okay. Please continue the cross-examination. And again, gentlemen, be mindful. 1, 2, 3.
Okay.
Okay. Please continue.
Okay. Thank you for your patience with my technical issue, Mr. President. Mr. Shop, we're going to move to a different topic. Your report highlights, in your words, highlights several issues with the BA Energy Solutions report. That's a quote from Version 2, paragraph 95, if you want to see it, but it's essentially, I want to get to the point that you raised some issues with the BA Energy Solutions report, correct?
That's right. In both our first and second reports, we raised some issues regarding being able to review the detail underlying it, the results it produced. We didn't ever make a change to that, but we do raise issues, I think is a good way to put it, right, about the BA ES report.
And just to be clear, what we're talking about, BA Energy Solutions spot price forecasts, correct?
That's correct. It's the monomic price forecast, which includes both the spot price and then sort of the guaranteed capacity payment. And in particular for the sort of farther out years of the forecast when the RER contract concludes and CHM would be selling in sort of this monomic spot market.
Yes. And to be clear, when I say spot price going forward, I'm referring to the monomic spot price. I may forget to use the word monomic. Mr. Shop, you're familiar with MINEM, the Peruvian Ministry of Energy and Mines, right?
Generally speaking, yes, I'm familiar with them and that they exist.
Okay.
And what they do broadly.
Did Respondents?
1, 2, 3. I'm sorry.
Mr. Shop, did Respondents ever provide you with any spot price forecasts from MINEM?
I would have to look back through the record. We looked on MINEM's sort of, I don't know if it's their website or for their publications at various points. I think there may be some of those even referred to within the BA Energy Solutions paper that they produced for BRG. I can't recall off the top of my head if Respondent ever sent us any of those or if we found them on our own or whether it was exactly a MINEM price publication. So I think, I don't know is probably the safest answer there.
But you don't include any MINEM spot price forecast in your reports, correct?
No, we don't. The comparator we have to BA ES is Interjects. There's a graph that shows that.
Mm-hmm. And are you familiar with Osinergman? For the court reporter, that's, I think that's been one of the defined terms that's been provided. Osinergman regulates and supervises the energy industry in Peru. Are you familiar with that, Mr. Shah?
Generally, yes.
Yeah. And did Respondents ever provide you with any spot price forecasts from Osinergman?
Again, I think the safest answer to that is I don't know. I don't recall any off the top of my head.
Sure, but you don't refer to.
Mr. Zabalos, you're coming right in and they're not finished with their translations. Please try. I'm sorry.
Yes. No, I apologize. And did respondents ever provide you with any spot price forecasts from Ossie Nerdman?
As I said, I think the safest answer is I don't recall. I certainly don't recall any specifically, but I don't know is probably the safest answer. We don't include any in our comparison.
And in my concern to count to three, I asked you the same question twice. What I meant to ask you was you don't refer to any Ossie Nerdman spot price forecasts in your reports, correct?
Yeah, I don't believe that we do.
Okay. Are you familiar with COES, which is the Comité de Operación Económica del Sistema Interconectado Nacional, which is responsible for planning and coordinating the operation of the generation, transmission, and distribution systems that form Peru's interconnected network?
I'm familiar. I know that's whether that was in our own research and looking for various tariff rates and looking for these capacity payment rates, or if it was discussed by BA Energy Solutions in their paper. I am familiar with COES, not the full name and description that you gave it, but yes, I've been on their website before, I believe.
And did you ever ask for any spot price forecasts from COES?
I don't believe that we did, no.
No. And did respondents ever provide you with any spot price forecasts from any Peruvian state entity?
I don't know that I don't believe that respondents did, to the best of my memory.
Okay. And you were never provided with any COES spot price forecasts, right?
Not to the best of my memory.
Okay. Did respondents ever retain an expert to provide an alternate spot price forecast?
No. Yeah, no, there was no separate expert retained to address the BA-ES forecast.
Did you ever ask respondents to retain an outside expert to determine a spot price forecast like the BA Energy Solutions report?
No, and I think, again, that's somewhat of a function of the fact that we don't change the energy price forecast in the DCF model. So it's not, we have questions about this forecast. It appears aggressive, certainly compared to Interjects, but ultimately we don't decrease the monomic price forecast used in the DCF.
Let's pull up paragraph 61 of your first report. Tom, can you pull that up on the screen, please? If you look at paragraph 62 of your first report, you state, I'm sorry, paragraph 61 of your first report, right here. Here you state that the base forecast is, quote, extremely bullish compared to recent market trends in Peru and other contemporary price forecasts, close quote. Do you see that?
That's right.
Okay. When you say contemporary price forecasts here, you mean price forecasts as of the valuation date, right?
Yeah, I think we could probably say an Interjects price forecast.
Okay.
Yeah, that would be a fine substitution in that sentence.
Yeah, so it wasn't multiple price forecasts. It was just the Interjects projections, correct?
Yeah, the recent market trends is, as the following sentence says, what happened between 12 and 17, but for the forecast period, Interjects is the comparator we have.
Okay. Let's take a look at paragraph 62 of your first report. Okay, and here you say, quote, given the divergence with recent price trends in the Interjects forecast, it is hard to believe that the BASE, which is the BA Energy Solutions forecast, accurately reflects the market's contemporaneous views regarding Peruvian electricity prices as of March 2017. Do you see that?
Yes.
Okay. Mr. Shop, in your DCF model, I think you just said you used the BA Energy Solutions spot price forecasts to run that model, correct?
That's right. We don't modify the price forecast.
Right. And using the BA Energy Solutions forecasts, you arrived at a fair market valuation of $3.4 million, correct?
Yes, excluding the additional cost offset. That's right.
Did you ever run your DCF model using the Interjects spot price forecasts?
We may have at some point. I don't recall the exact number.
And if you did, you'd expect it to result in a lower fair market value, right?
Yeah, lower, I think possibly slightly negative based on the forecast being lower. I mean, again, that's a reason not to just sort of pick and choose, cherry pick one variable and substitute it into a model. Interjects had its own model, which, as we said, has an associated value, implied value of 7.2 million, just cherry picking their price forecast. We didn't think would be appropriate. That's why we didn't do it. But sitting here now, I'm guessing that's a lower, if not slightly negative FMV if you were to use Interjects, if I had to guess.
Okay, let's pull up.
Mr. Ceballos?
Yes.
Yeah, remind you about the 3 seconds.
I'm sorry, Mr. President.
I know you want to keep space in the examination, which I understand, but please remind us that we have court reporters and interpreters.
Thank you. Old habits die hard, Mr. President. I'll do my best.
I know. We'll keep you reminded.
Could we please pull up claimant's demonstrative number 5? Mr. Shop, this demonstrative shows the results of your DCF model after running it using the Interjects spot prices. Do you see that this results in a negative fair market value of $5.1 million about?
I see what that says. I'll take it, sort of take your representation that number is correct and the model's been run correctly, but again, that's not a very surprising result.
Okay. No one would invest in a project with a negative DCF valuation, right?
No, and I think that would be a reason not to just substitute Interjects' spot price into the DCF, into our DCF, which is one of the reasons why we didn't do that or wouldn't do that. Interjects, again, had its own DCF that had its price forecast, all of its other assumptions regarding cost, growth, production, budget, discount rate. And if you run that on its own terms, it's a DCF value, implied value of $7.2 million. So, but no, to your specific question, I don't think anyone would invest in a project with negative MPV.
Tom, you can take this down. Let's pull up paragraph 3 of your first report. Okay. So, Mr. Shop, this is paragraph 3 of your first report, and it defines the measures at issue in this dispute. And those measures are the lawsuit by the regional government of Arequipa on 14 March 2017, which sought to revoke certain environmental permits previously granted to Mamacocha. 2, the filing of criminal charges by Arequipa's environmental prosecutor in March 2017. 3, the denial of Mamacocha's civil works authorization in May of 2017. And 4, MINAM's refusal to grant extensions to account for the delays caused by the lawsuit and its commencement of an arbitration in Lima to nullify prior extensions. Do you agree that these are the measures alleged by claimants for the purposes of, that you referred to for the purposes of preparing your first and second reports?
That's right. This is sort of a background section. I don't know that we intended for this to be the be all end all. Obviously, these are claimants' allegations and are sort of factual and legal issues. We're just summarizing what we understood to be the breaches alleged that were relevant, but to the best of our understanding and ability.
And Mr. Shop, have you reviewed the full factual record and testimony in this case to form an opinion as to the potential impacts of the measures on your evaluation?
I'm not entirely sure. Have I read every page of every exhibit and legal authority and witness statement and expert report? I don't believe so. We certainly looked at the index of documents and tried to identify everything that could be relevant. I think it's a pretty big record in this case. There was document production, there were lots of other things. So I don't know that I can say I've read every page, no.
Okay. Let's pull up paragraph 129 of your first report. Okay, in this paragraph, you cite to a separate paragraph from an email from Mr. Sillen to support your contention, quote, that Interjects later became concerned that the project was not as attractive as it initially thought. Do you see that it's in the paragraph above the quote?
That's right. It appeared to be the case. We're not testifying on matters of fact, but that's what appeared to be the case based on that email.
Okay, let's turn to exhibit C168, which is the email cited in paragraph 129 of your report. Okay, Mr. Shop, who provided you with this exhibit?
I don't recall. I don't remember if that was something from the record or if it was from something claimants had produced. It was from respondent or the lawyers. I can't recall. We didn't have it on our own to start with.
And did anyone tell you how to interpret the meaning of this email?
No, I don't really understand what you mean by that.
Did anybody tell you how to interpret the meaning of this email?
No.
Okay. Let's turn to paragraph 130 of your report. Here in this section, this paragraph immediately follows the paragraph that we just discussed. Here in this paragraph, you imply that Mr. Sillen's testimony is referring to revisions by POIRI to the project's average electricity generation, correct?
No, that's not correct. I think those are separate. It's Mr. Sillen appeared to be saying they are less positive about the project, and we are saying separately from his email or what he might have thought that there was one potentially meaningful development during this period, which was this decrease in the expected generation capacity from 140,000 megawatt hours per year to roughly 135. So we're not trying to suggest that that's what Mr. Sillen meant or that's what Interjects meant, just that it appeared that there was some concern on Interjects' part that it wouldn't be as attractive as originally conceived, and that this is one potential development that appeared meaningful, given that it's a decrease in revenues without any change in costs. We're losing, I don't know, what is that, 3.5–4% of revenues because of the lower generation potential. But we're not trying to put words in Mr. Sillen's mouth. We're just observing that this was a change that occurred during that period of time.
Right, but when you quote Mr. Sillen in 129 and you say the project was not as attractive as initially thought, one of the reasons you think that Interjects might have thought the project was not as attractive as originally thought is POIRI's forecast revision that's referenced in 130. Is that right? Am I understanding you right?
Well, that could be a reason. I mean, we see that Mr. Sillen, and I think that's a direct quote, their main concerns are time and that the project is not as attractive to them as they thought it was when they started negotiations, indicating that they would like to improve the deal. So he said, okay, what could explain this change in perceived value that they wanted to maybe renegotiate terms? And one thing that would somewhat obviously have an effect on Interjects' evaluation of the project is a 4% revenue drop without a corresponding decrease in costs or any other change. You know, that's really just a direct hit to value. So we're not suggesting that that is what specifically they meant. Mr. Sillen doesn't say what they meant. I don't know that he says one way or another, but we're not trying to put words in his mouth. We're just saying this is a development which would have been, or at least very likely could have been viewed negatively by Interjects during that intervening period that's referred to.
Okay, but you acknowledge, Mr. Shop, that Interjects knew about this forecast revision no later than March 1st, 2017, right?
I think we know that that's when POIRI, sort of the report is dated or maybe was mailed. I don't know if and when, or at least when, that would have been delivered to Interjects by the claimant. Yeah, but I think what we know is that the POIRI report the estimate was revised on March 1st. As to when it was delivered to Interjects, that I don't know.
Okay.
Probably around that date, I would think.
Trying to observe the 3-second rule a little bit better here. And March 1st, 2017, Mr. Shop, that's prior to the valuation date, while Interjects' offer was pending, right? Interjects' 2017 offer was pending, right?
Yeah, that's what I understand to be the case. The valuation date's, I think, March, 14th, 2017. So
that's correct, Mr. Shop.
Yeah.
And you don't identify any report, I'm sorry, and you don't identify in your report any document in the record that suggests that the terms of Interjects' pending offer changed between March 1st and March 14th, 2017, right?
No, I think, you know, when we look at the Interjects deal, we look at the February 2017 proposed terms. So what we're looking at here is kind of what might explain that gap between this sort of 3.4 and roughly $8 million that is the correct value implied by the Interjects deal. And this is one potential explanation of that. We're not trying to change the Interjects offer. It was what it was in February 2017. This is just an attempt to say, why might those numbers be that sort of $4-ish million difference at that point?
I'm just trying to understand what you just said, Mr. Sub. So it's your position that the project lost more than half of its value between February of 2017 and March 14th of 2017?
No.
No.
That's not my position. Interjects value is one marker indicator of value. The value implied by the Interjects Feb 2017 offer was $8-ish million. Our DCF comes up with $3.4 million. This is saying, well, is there something that might sort of bridge some of that gap between these numbers? And one thing is that our DCF, which uses the lower generation amount from POIRI of $135,000, which is lower than the generation amount that Interjects would have used in its evaluation in February, that may explain some of the gap. And if you were to go into Interjects' financial model, which previously had a value of $7.2 million, change the generation capacity, that would reduce their DCF from 7.2 to 4.9 million. So again, saying our DCF relies on up-to-date numbers in March. Interjects' offer and DCF relied on older previous numbers. If you correct that one element of their DCF, update it, our results become more in line. They're still not perfectly aligned. I mean, you wouldn't expect two values to be exactly the same, developed using different models and different methods, but they're reasonably close.
But Interjects never decreased its offer, right?
Other than this email saying that they are saying the project's not as attractive that they thought and they would like to improve the deal, I'm not aware of any sort of firm conclusion to that. But yeah, I mean, there's an indication they were looking to do that. But when we talk about the Interjects offer, we're talking about the February 2017 offer.
Mr. Shop, are you aware that the RGA lawsuit was filed on March 14th, 2017?
Yes.
And are you aware that the Arequipa environmental prosecutor filed a criminal lawsuit based on the allegations in the RGA lawsuit on March 24th, 2017?
I'll take your word on that exact date.
Okay.
I'm aware of that general time frame, certainly.
Okay. And are you aware that on May 16th, 2017, the Regional Water Authority, the AAA, denied the project its civil works authorization?
Again, I'll take your word on the date. We may refer to that specifically somewhere in our report.
Okay. And are you aware that claimants contend that each one of these actions that I just described to you comprise at least one of the measures alleged in this case?
Yes.
Right. And so you agree that each of the measures I just referenced took place between March 14th, 2017 and May 16th, 2017, correct?
Assuming the dates you gave are correct. I apologize, I don't have them memorized, but I'll take your word for it.
Okay, let's pull up C0168 again. Mr. Sillen, the date of this email is May 17th, 2017, correct?
Correct.
And that's after all of these three events had occurred.
Chronologically, that would be true, yes.
Right. And all of these occurred after the valuation date, right?
Yes, they're after March 14th.
Okay. Are you aware that this exhibit C168 was included as part of Mr. Sillen's testimony in this case, in his first witness statement?
I should have checked the site. Maybe that's what we cited it to. Yeah, I believe so. We would have reviewed his expert or his witness statement and the associated documents.
Okay, let's turn to Mr. Sillen's first witness statement at paragraph 133. Okay. In paragraph 133, Mr. Sillen says, quote, "I kept Interjects and DEG informed of these events as they transpired. Both entities were sympathetic, but neither wanted to move forward with their respective agreements with Latam Hydro until a resolution to the RGA lawsuit was reached. Even if we could somehow obtain a resolution to the RGA lawsuit, the existence of the criminal investigation and the issues with the AAA permit made it difficult, if not unlikely, for Interjects and DEG to restore their faith in the project. In May 2017, Interjects confirmed to us that the regional opposition meant that the project was, quote, not as attractive to them as they thought it was, close quote, earlier in the year." Do you see that?
I see that's his witness statement, yes.
And I think you just said you would have considered Mr. Sillen's testimony when you prepared your reports. Is that right?
We certainly reviewed it, yes. Yeah.
But you don't mention Mr. Sillen's testimony in paragraph 129 or paragraph 130 of your report.
I'll have to check the sites, but no, we may not. And again, the concluding part of that email is indicating that they would like to improve the terms of the deal. So it didn't seem to be a total lack of interest. It's it's not they were walking away, apparently. They wanted to improve the terms of the deal, which we assume meant commercially.
Just give me 1 second. Okay, I have no further questions, Mr. Shop. Thank you.
Thank you, Mr. Ceballos. Ms. Endicott, are you still online?
I'm here, just trying to minimize the number of video windows you need to have open because I know it makes them so small.
I understand. Do you need time to review the questions you want to ask in redirect, or do you have any questions actually for redirect?
I may have just a couple. If with the tribunal's indulgence, could I have just say 10 minutes to confer with my team briefly?
By all means, because normally we would have now already lunchtime on your time zone and dinner in my time zone, but it's pretty early, I can tell you. So if we can adapt the schedule, so take your 10 minutes and then come back and then tell us how you would like to proceed.
Thank you. Appreciate that.
Okay, 10 minutes recess until 16:35 CET. I see everybody is back. Ms. Endicott for the respondent, the redirect. Any questions?
Yes, just one.
Just one. Okay, please go ahead.
Today, during your cross-examination, Mr. Shop, Mr. Ceballos posed a hypothetical to you at page 49, line 16 of the transcript about a revenue-producing project that was a farm. At page 52, line 1 of the transcript, you responded that you don't really think that the hypothetical goes to the issue at hand here. Could you explain why not?
Sure. So in that hypothetical, what was being compared was sort of the future DCF value of a farm compared to what it would cost to get it up and running. I don't think there's any dispute that that's how projects work. You pay something up front and you get benefits later on. But that's not what we're talking about here. We're talking about assessing the implied value from a known series of offers for this specific project and figuring out what we can do with the value using that data. It's not projecting cash flows. It's not a DCF versus costs, revenues versus costs. We know for a fact that claimants were offered somewhere between $7 and $8 million for their project. We know that in the sort of February 2017 Interjects offer, Interjects was willing to invest $17.8 million to receive a 70% share in what would become post-investment a $28 million project. So this sort of general hypothetical of costs up front and cash flows later and whether somebody invests or doesn't invest, that's really not what we're talking about here. We're talking about assessing known offers that imply values in a very tight range of $7 to $9 million. And that farm example doesn't get to that point because it sort of assumes that the DCF is what matters when what we're talking about is the offers themselves in that case.
Thank you. I have no further questions.
Thank you, Ms. Endicott. Mr. Tabil, any questions from the tribunal?
Thanks, Mr. President. I just want a clarification, only one clarification. Could I ask if Versant could put in the screen, or someone, Tom, I don't know, slide 18 of their presentation today?
I'm happy to if you'd like me to do it, but yeah,
please.
Need to open it up. Sorry.
I'm going to start with a question. I mean, if I understood correctly, your main questioning of BRG's DCF was the issue that they took it into account, the sort of the value, not taking into account that Interjects had not injected the money to the project, so that it was sort of inflated because it was considering money that was not yet injected. Now the question is, how does this slide 18 relate with the other thing? Because I mean, you're saying here that the BRG's valuation is inflated by 322. Which valuation? The valuation where you already deleted the 17 or 18 million? Because I mean, I just don't understand how you say it's inflated if you have already discounted the 18 million of Interject not in the project. Thanks.
Think of them as two completely separate things. There is BRG's assessment of the Interjects offer, which they say implies a value of $27 million. That's where we would say you've incorrectly included $18 million in costs that are in funds that Interjects would invest. That version, that analysis by BRG, correcting the Interjects no investment, decreases it from 27 to roughly 9. This is separate to that. This is BRG's DCF, which doesn't incorporate Interjects. Interjects isn't part of this DCF. It just assumes claimants would fund any equity investment, they would get future revenues. So there is no Interjects in this DCF world.
I understand now. If you deduct the Interject investment not made, are we still having a valuation inflated by 322%?
Their DCF valuation, which doesn't consider Interjects at all, is still inflated because they use a discount rate which is too low, performance bond, et cetera. Kind of mechanically, you could get to almost the same place if you just deducted 18 million from it, but that's coincidental. These are truly separate analyses. The 18 million subtraction only applies to BRG's assessment of the Interjects offer. Separately, in BRG's DCF, which does not consider Interjects as part of it, the reason that analysis is inflated is because of these 5 discrete, what we would call errors in their DCF. So you can sort of forget about Interjects when you're talking about the DCF model because it's not modeled in there.
Okay, thank you. I have no further questions, Arborian.
Thank you. Professor Vinuesa, any questions?
No, I have no question. Thank you.
I have also no questions. Ms. Endicott, any questions, follow-up questions from questions arising from the tribunal?
No, thank you.
Mrs. Ceballos, any questions arising? Mr. Ceballos, you are on mute.
No, Mr. President, I have no further questions. Thank you. At least that forced the 3-second rule.
Well, in the end, we got it all right. Mr. Shop and Mr. Siqueira, thank you for testifying as an expert witness. You're now excused.
Thank you, Mr. President.
All right. Ms. Endicott, you are still, you disappeared immediately from the screen. No. And Mr. Granet for the respondent, and Mr. Ceballos. So what the tribunal proposes is now also to have the presentation by the United States, the NDP presentation, because then we can conclude the day in say 30 to 40 minutes. Is that acceptable to the parties? It's acceptable to the United States that we inquired with them.
I will need a few minutes to consult with my team, Mr. President. Is that okay? Could we have a 5?
But it's an early day that you have that, huh? So that's okay. And Mr. Granet, do you need us to consult?
No, Mr. President, we are perfectly fine to proceed. Of course, it's really the US who needs to tell us if they're ready, and they have, so we are ready to proceed.
Okay. I see Ms. Thornton and Ms. Grosch online. Ms. Thornton, bear with me for a second. Thank you for being prepared to do your presentation early, but we have to wait until claimant has taken instructions internally.
I'll be as quick as I can, Mr. President.
By all means, please take your time.
So can I get a clarification? Ms. Thornton and Ms. Grosch, will you both be speaking?
No,
thank you. Yes, just Ms. Thornton for the United States today.
Okay, thank you.
Ms. Thornton, while we are a little bit on downtime, this the question I had last time also to I think your colleague, I don't know who it was in the other case. And I asked the question, where's the book? You remember that? Did he,
oh my goodness.
This is now 20 or so years old. And I so asked the USMCA, where is it? So do you have a comparable book, probably comparable volume? But it would be very helpful. And so still under consideration, the book?
Yes, well, your book is in much better condition than mine, but we will inquire about that. I have not seen a new version of the book, but thank you for the reminder.
Okay, well, each time when one of you appear, I ask the same question. So eventually I land on your desk again. Okay, well, thank you.
Mr. President, I apologize for the delay. We're ready to proceed.
Thank you. Thank you. With the consent of both parties, then let's proceed. Ms. Thornton, you have 30 minutes to make an oral presentation on behalf of the United States as a non-disputing party.
Great. Thank you, Mr. President and members of the Tribunal for this opportunity. Good morning. I will just make some very brief remarks on behalf of the United States today, pursuant to Article 10.20.2 of the U.S.-Peru Trade Promotion Agreement, or TPA. Today, I will address 5 questions of treaty interpretation arising out of the parties' responses to the U.S. written submission dated November 19th, 2021. I will address first the weight of non-disputing party submissions. Second, the relationship of the waiver requirement and claims that may be brought under Article 10.16.1. Third, the customary international law minimum standard of treatment. Fourth, the most favored nation treatment standard and the non-conforming measure exception in Article 10.13.2 and Annex 2 of the TPA. And fifth, the meaning or lack thereof of silence on any topic in U.S. non-disputing party submissions. So I begin my remarks by addressing the weight due to U.S. views on matters addressed in a non-disputing party submission. States are well placed to provide authentic interpretations of their treaties, including in proceedings before investor state tribunals like this one. Article 10.20.2 ensures that the non-disputing party to a dispute under the U.S.-Peru TPA can provide its views on the correct interpretation of the TPA. The TPA parties consider non-disputing party submissions to be an important tool in this respect, and the United States consistently includes non-disputing party provisions in its investment agreements to reinforce the importance of these submissions in the interpretation of the provisions of these agreements. And we routinely make such submissions. Article 31 of the Vienna Convention on the Law of Treaties recognizes the important role that the states parties play in the interpretation of their agreements. Although the United States is not a party to the Vienna Convention, we consider that Article 31 reflects customary international law on treaty interpretation. Article 31, paragraph 3 states that in interpreting a treaty, there shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty or application of its provisions, and any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. Article 31 is framed in mandatory terms. It is unequivocal that subsequent agreements between the parties and subsequent practice of the parties shall be taken into account. Thus, if the tribunal concludes there is either a subsequent agreement between the parties or a subsequent practice that establishes such an agreement regarding the interpretation of a treaty provision, the tribunal must take that into account in its interpretation of the provision. Where the submissions by the two TPA parties demonstrate they agree on the proper interpretation of a given provision, the tribunal must, in accordance with Article 31(3)(a), take this agreement into account. In addition, the TPA parties' concordant interpretations may also constitute subsequent practice under 31(3)(b). In response to arguments that non-disputing party submissions are not entitled to deference because they are made in the course of arbitration, this is simply not true. The TPA parties expressly included the mechanism to provide interpretations to investor state tribunals in the course of an arbitration for a reason. Indeed, the International Law Commission has commented that subsequent practice may include statements in the course of a legal dispute. Accordingly, where the TPA parties' submissions in an arbitration evidence the common understanding of a given provision, this constitutes subsequent practice that must be taken into account by the tribunal under Article 31(3)(b). Now, I would note as well that in its written observations on our non-disputing party submission, Peru agreed that the TPA parties have reached either a subsequent agreement or subsequent practice with respect to those treaty provisions on which they have evidenced their common understanding through their submissions in this proceeding. Additionally, investment tribunals have agreed that submissions by the NAFTA parties in arbitrations under NAFTA Chapter 11, including non-disputing party submissions, may serve to form subsequent practice. For example, the Mobile v. Canada Tribunal found that arbitral submissions by the NAFTA parties constituted subsequent practice and observed that, quote, the subsequent practice of the parties to a treaty, if it establishes the agreement of the parties regarding the interpretation of the treaty, is entitled to be accorded considerable weight, unquote. I'm quoting from paragraph 158 of the Mobile v. Canada decision on jurisdiction and admissibility, dated July 13th, 2018. And I would point you also to paragraphs 103, 104, and 158 to 160 of that decision for context. The tribunal and Canadian Cattlemen for Fair Trade, of course, reached a similar conclusion at paragraphs 188 to 189 of its award on jurisdiction, dated January 28th, 2008. I would also note, in response to comments on this issue, that TPA Article 10.22.3, which concerns interpretations by the Free Trade Commission, and Article 10.20.2, which concerns non-disputing party submissions, merely establish separate mechanisms for the parties to provide interpretations of their treaty. Nothing in the TPA's text suggests, in granting the Free Trade Commission ability to issue binding authoritative interpretations of the TPA, that the parties intended to preclude themselves from issuing non-binding but nevertheless authentic means of interpretation of TPA provisions.
Ms. Horton, there was an issue on with the sound. Could you please repeat the last sentence as of nothing in the TPA text? Then
Thank you. Thank you. I hope it's not my bandwidth. Apologies for that.
Okay, it's okay.
Nothing in the TPA's text suggests that in granting the Free Trade Commission the ability to issue binding authoritative interpretations of the TPA, that the parties intended to preclude themselves from issuing non-binding but nevertheless authentic means of interpretation of TPA provisions through their submissions to investor state tribunals, or to preclude a tribunal from giving such submissions the weight to which they would otherwise be entitled. To sum up on this first point, whether the tribunal considers that the interpretations presented by the two TPA parties as a subsequent agreement under 31(3)(a), as a subsequent practice under 31(3)(b), or both, on any particular provision, the outcome is the same. The tribunal must take the TPA parties' common understanding of the provisions of their treaty into account. The next topic I will address concerns the relationship between the TPA's waiver requirement and claim may be brought Article 10.18.1. Article 18.2b requires that claimants
Perdón,
waive any right to
perdón, disculpe que interrumpa. Soy el estenotipista en español. Hay un problema con el sonido y está siendo difícil la interpretación y además va un poco rápido también. No sé si será un problema con el micrófono.
Okay, de acuerdo. Ms. Thornton, two questions about the interpreters. One is, could you please slow down a little bit?
I got that, yep.
So if you go to 50%, that's okay. I grant you more time then. So don't worry that you then have to complete in 30 minutes. I will give you more time, but of course then you have a better transcript and better interpretation. And point two is that there is an issue still with your bandwidth, I guess. And so could you start again at when you said next topic, the next topic is, and then you started
Yes.
or to waiver your word. Okay.
I will, thank you. And if I continue to have difficulties, I apologize. I may need to ask my colleague to step in, but I will continue until you tell me otherwise.
No, don't worry. I will check it, keep monitoring the situation.
Okay, thank you. The next topic I will address concerns the relationship between the TPA's waiver requirement and claims that may be brought under Article 10.16.1. Article 10.18.2b requires that claimants waive any right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedures any proceeding with respect to any measure alleged to constitute a breach referred to in Article 10.16. In our November submission, the United States stated that the waiver provision does not preclude the concurrent submission of treaty and contract claims under Article 10.16.1 before one tribunal, provided that issues such as potential double recovery and inconsistent findings are otherwise addressed. Article 10.16.1, however, under Article 10.16.1, however, only the claimant on its own behalf or the claimant on behalf of an enterprise of the respondent that it owns or controls directly or indirectly may submit to arbitration a claim that the respondent has breached an obligation of Section A of the TPA's investment chapter, an investment authorization, or an investment agreement. Thus, while the TPA contemplates that certain treaty claims may be brought together with certain contract claims, such claims may not be brought under Article 10.16.1. They may only be brought under 10.16.1 by a claimant investor. Article 10.16.1 does not provide standing to a domestic enterprise of the respondent that the investor owns or controls for the enterprise to bring a claim itself, nor does it provide for the joinder of other claimants. The third topic of my remarks concerns the customary international law minimum standard of treatment. TPA Article 10.5 provides that each party shall accord to covered investments treatment in accordance with customary international law, including fair and equitable treatment and full protection and security. This provision prescribes the customary international law minimum standard of treatment of aliens as the minimum standard of treatment to be afforded to covered investments. Annex 10A to the agreement addresses the methodology for determining whether a customary international law rule covered by Article 10.5 has crystallized. The annex expresses the parties' shared understanding that customary international law generally, and as specifically referenced in Article 10.5, results from a general and consistent practice of states that they follow from a sense of legal obligation. Thus, in Annex 10A, the parties confirmed their understanding and application to elements state practice and opinion.
Sorry, can you?
Yeah, I know, Laurie. Sorry, Ms. Thornton, can you please repeat the last sentence? Does Annex 10A?
Yes, in Annex 10A, the parties confirmed their understanding and application of this two-element approach, state practice and opinio juris, which is the standard practice of states and international courts, including the International Court of Justice. As the United States observed in our written submission, decisions of international courts and arbitral tribunals interpreting fair and equitable treatment as a concept of customary international law are not themselves instances of state practice for purposes of evidencing customary international law, although such decisions can be relevant for determining state practice when they include an examination of such practice. A formulation of a purported rule of customary international law based entirely on arbitral awards that lack this examination of state practice and opinio juris fails to establish a rule of customary law as incorporated by Article 10.5. The United States, therefore, does not assert that arbitral awards are without relevance. Our submissions do cite to arbitral awards concerning the minimum standard, but we cite to certain awards such as Glamis because they correctly observe that arbitral awards do not constitute state practice and cannot by themselves create or prove customary international law. We acknowledge that arbitral awards can be relevant and illustrative, where they have examined state practice and opinio juris in order to determine whether a purported element of fair and equitable treatment has crystallized into a rule of customary international law within the minimum standard. Finally, on this topic, I would also note that while the TPA parties consented to allow investor state tribunals to decide issues in dispute in accordance with the agreement and applicable rules of international law, they did not consent to delegate to Chapter 10 tribunals the authority to develop the content of customary international law, which must be determined solely through a thorough examination of state practice and opinio juris. The fourth topic I will address elaborates on the US interpretation of the most favored nation treatment standard contained in Article 10.4. As stated in our written submission, for a claimant to establish a breach of the most favored nation treatment obligation under Article 10.4, the investor has the burden of proving that it or its investments, 1, were accorded treatment, 2, were in like circumstances with identified investors or investments of a non-party or another party, and 3, received treatment less favorable than that accorded to those identified investors or investments. This means that if the claimant does not identify treatment that is actually being accorded with respect to an investor or investment of a non-party or another party in like circumstances, no violation of Article 10.4 can be established. In other words, the claimant must identify a measure adopted or maintained by a party through which that party accorded more favorable treatment, as opposed to speculation as to how a hypothetical measure might have applied to investors or investments of a non-party or another party. Moreover, a party does not accord treatment through the mere existence of provisions in its other international agreements, such as umbrella clauses or clauses that impose autonomous, fair, and equitable treatment standards. Treatment accorded by a party could include, however, measures adopted or maintained by a party in connection with carrying out its obligations under such provisions. As we additionally observed in our written submission, a claimant must establish that the alleged non-conforming measures that constituted less favorable treatment are not subject to the exceptions contained in Annex 2 of the TPA. In that annex, both parties reserve, in accordance with Articles 10.13 and 11.6, the right to adopt or maintain any measure that accords differential treatment to countries under any bilateral or multilateral international agreement in force or signed prior to the date of entry into force of this agreement. Annex 2 does not require the states parties to affirmatively exercise an Annex 2 reservation for a generally applicable measure. As the explanatory notes to Annex 2 provide, in accordance with TPA Article 10.13.2, the articles specified under the heading Obligations Concerned in a state party's entry to Annex 2 simply do not apply to the sectors, subsectors, and activities identified in that entry. No further action by a state party with respect to the non-conforming measures described is required. Moreover, Annex 2 provides that the state's parties reserve the right to adopt or maintain measures according differential treatment. This provision excludes pre-existing non-conforming measures and not just ones adopted in the future from the obligations listed. This condition, common in trade and investment agreements, is intended to recognize that the parties to such negotiations.
Can you please
Yes.
repeat the last sentence? You
Yes.
faded. Yeah, thank you.
So I was noting that the language is that the parties reserve the right to adopt or maintain measures according differential treatment, and that provision excludes pre-existing non-conforming measures and not just ones adopted in the future from the obligations listed. This construction, common in trade and investment agreements, is intended to recognize that parties to such negotiations commonly have existing measures that they are not agreeing to remove. And the formulation was necessary to avoid a situation where a state might be in non-compliance with its obligations as soon as the treaty entered into force. Requiring a state party to affirmatively exercise such a reservation of rights would be nonsensical and common language, context, and purpose of Annex 2. Finally,
I did not get that last sentence.
Sorry about that. Yes, the last sentence was requiring a state party to affirmatively exercise such a reservation of rights would be nonsensical and contrary to the language, context, and purpose of Annex 2. I'm quite close to done, so hopefully we can get through this. Finally, I would just emphasize that the United States stands by the interpretations set forth in its written submission, although we did not address all of those issues today. And this brings me to my final topic, the issue of silence and issues of interpretation which a U.S. non-disputing party submission, whether written or oral, does not reach. In every non-disputing party submission we make, and we do so here, the United States explains that the submission takes no position on the application of the treaty to the facts of the dispute, and that no inference should be drawn from the absence of comment on any issue not addressed in it. Rather, a non-disputing party submission aims to share the proper interpretation of disputed treaty provisions in a way that is helpful to the tribunal. In any given case, there may be numerous interpretive issues in dispute that the United States chooses not to address. We make it perfectly plain that it would be incorrect to read into our silence, any particular position on the topics not addressed. As the standard US assertion on silence makes clear, silence is not acquiescence to any interpretive position advanced by either disputing party in a case. And with that final observation, I will close my remarks and thank the tribunal again for the opportunity to present the views of the United States on these important interpretive issues.
Thank you, Ms. Thornton, for presenting the view of the United States as a non-disputing party. you may stay on, of course, online as a non-disputing party. I'm going now back to the council for the claimants. I see Mr. Granet for the respondent. Okay, Mr. IJsveld. We come to a conclusion of the day, unless there are other business to transact. We can then adjourn until Friday. But are there any points you would like to raise, Mr. IJsveld, the procedure, admin, or household?
Claimants do not have anything to raise at this time.
Thank you. Mr. Granet?
Nothing at this time, Mr. President. In the unlikely event that something arises before closing arguments on Friday, we'll be sure to write to the tribunal and hopefully try to resolve any issue with opposing counsel before we do so. But at this moment, we have nothing. Thank you.
All right. I look to my co-arbitrators. Professor Tawil, anything further?
Not, Mr. Chairman, thanks.
Professor Venuesa?
No, thank you.
Anna, are you still? Anna, is there anything from ICSID's perspective?
Nothing from our end. Thank you.
Okay, thank you. Then I close for today and see each other on Friday. And if there's a question arises in the meantime by the parties, please feel free to contact us. There's always a copy to the other side.
Thank you.
Thank you.